Hello, and welcome to the Pierian Gallery, and thank you for coming out to join us at our lecture event this evening. My name is Jeff Schaefer, and I direct the Hale Institute, and we are glad to have with us Professor Scott Yenor to discuss one of the more prominent of the Supreme Court's Equal Protection Clause case decisions, specifically the case of United States versus Virginia, in which the court considered a complaint of sex discrimination leveled against the storied Virginia Military Institute. Though it had been a male-only institution from its inception in 1839, and throughout that time it acted entirely in keeping with the national tradition of state and federal sponsorship of all-male military academies, the Supreme Court in 1996 nevertheless determined that VMI must convert itself to a co-ed institution to conform to the 14th Amendment's Equal Protection Clause, or at least to the court's novel view of that clause. Now, I understand Professor Yenor will have some critical observations to offer about the court's ruling, as well as Justice Ginsburg's majority opinion for the court, as well as some details on VMI's condition since the court's ruling and the school's cooperation with it. But in the meanwhile, and before introducing Scott, what I aim to put forward for a few minutes is commentary on the court's curious approach to the Equal Protection Clause, and particularly as it relates to the sexes. For those of you who have not read the 14th Amendment in a while, I remind you that its momentous Section 1 includes, among other standards, the requirement that no state shall deny to any person within its jurisdiction the equal protection of the laws. Now, a couple of things with respect to that provision. First, the Supreme Court has shown a curious disregard for its text. As Jonathan Mitchell has put it, the Supreme Court now acts as if the word protection had never been enacted. The justices instead proceed as if any law that classifies or discriminates implicates the Equal Protection Clause. That is, not just those laws that offer persons protection, all of them. And the court has designed its own criteria for determining what level of scrutiny and kind of justification should apply to validate different types of such laws and their classifications. All of this emerges from the court's ingenuity rather than having a grounding in constitutional text or tradition or legal history. Now, the concern here is not merely that every state law is now in principle subject to court scrutiny and disqualification, but also because equality as a legal standard presents a command empty of content once it has been detached from the confines of the 14th Amendment's text. And being an empty standard, it leaves the court with untethered discretion rather than legal guidance and restraint when composing its rulings. So I'll explain this slowly. Aristotle, in his Nicomachean Ethics, offered the now standard form of the equality rule. You may be familiar with this. I quote him: "Equality in morals means this: things that are alike should be treated alike, while things that are unalike should be treated unalike in proportion to the unalikeness." The Supreme Court's version of this is to describe its equal treatment rule to apply to persons similarly situated to each other. So, let's ask, does an all-male military institute, by excluding women from enrollment, honor the equality command of justice because it treats differently persons who are, in this context, unalike, and does so in proportion to that unalikeness? Or does it violate equality by treating like things as if they are unalike? We might ask the same question as to the federal statute that requires young men reaching the age of 18 to register for the Selective Service, being thus recorded for purposes of a future military draft, but not requiring such registration for young women. Does that federal policy honor the justice of equality because it treats two classes of people differently that are unalike for purposes of this circumstance in a way that's proportionate to their unalikeness? Or does it violate equality by treating two classes that are relevantly similar in a way that is dissimilar. That is, are men and women interchangeable, equally suited in nature and calling to military combat? The claimed obligation of equality does not answer these questions. Again, because the equality imperative is substantively empty. Only after a different normative standard has done the work of discovering if the compared groups are relevantly similar or dissimilar in the context at issue can the equality obligation then be applied. Which means that the rhetorical invocation of equality or equal rights, or worse yet, equal protection, obscures that it is in fact an altogether different standard that actually governs the outcome insisted upon, not equality, which contributes nothing to the resolution of the question. Now, a second point. The Supreme Court for decades has feigned to struggle to find permissible reasons or important government interests in state laws that treat men and women differently, or that claim to be honoring and regulating in terms of the nature and distinct callings of each sex. The court's starting baseline of suspicion as to state laws addressing males and females differently, except in the context of pregnancy, which the court has conceded to be a uniquely female aptitude, is translated into the court codifying its suspicion as if its feminism were not a contemporary ideological fashion, but instead a benchmark of constitutional law. This led Justice Scalia to complain in his dissent in the VMI case that the institution of representative lawmaking, quote, is destroyed if the smug assurances of each age are removed from the democratic process and written into the Constitution. Here I'll suggest parenthetically that if male and female are not understood in law as objective and unique states of being with distinct personal and community significance, if the sexed human body is not seen as revelatory of identity, nuptiality, and social relational meaning, then the family, as it has been historically known, evaporates as a public category, which of course starts to explain how we got to the Obergefell ruling. In this condition, the continuance of traditional family prerogatives can only be tentative and precarious, existing at the dispensation of the civil powers and on their terms. There is indeed a flummoxing aspect in how the Supreme Court approaches state laws that defer to and thus declare upon matters of human meaning, such as when approaching concerns over the definition of marriage or innocent human life or the peril and medical and social transing. The Supreme Court addresses these matters of primal civilizational dimension as if they were nonetheless subject to, and indeed presumptively at risk before, the court's recent and contingent standards in its anti-sex discrimination law. That is, the court puts forth on these matters so central to human nature as if the court's own idiosyncratic and recently made up standards of analysis and reasoning exhaust the acceptable forms of justification for the nation's laws that have a pedigree going back centuries or even millennia, and whose purposes and grounding are in observable human nature and immemorial custom, not in whatever the court in recent decades has concocted and then declared to be the exclusive reasons for which we're allowed to enact laws. And the result of all of this in litigation before the court is that the points of human reality at issue are often not ventilated at all. For to do so, for a lawyer to argue, for instance, that male and female are aspects of human nature whose legal recognition and differential treatment are non-negotiable orienting points of justice and are grounds for coherence to human existence in the first place, would be to run into the court's equality case law, whose terms convey that it is at least suspect, if not always illegal, to do that distinguishing and discriminating between male and female. And so to gain the court's favor, as all litigants wish to do in order to vindicate their cause, often requires suppressing and converting the principal reason for their laws or other claims into proxy arguments that rely on second-order empirical or scientific explanations, such as that Men on average have strength to carry wounded comrades out of battle, whereas women on average do not. Rather than moral and anthropological explanations such as that it is a disgrace to make women cannon fodder behind whom the nation's men crouch in protected appreciation. For such anthropological precepts implicate what the court usually classifies as illegitimate sex stereotypes. But it's not just that this proxy argumentation that litigants are forced into adopting infects court proceedings. Such justifications for laws also appear at all points of public discussion before then, too, because they anticipate the contest will later be resolved by the courts. Likewise, for the advocates lobbying for and explaining new legislation, they offer curated justifications that adhere to the Supreme Court's categories of deemed kosher priorities. Why? Because these advocacy statements of reason and purpose are those that the courts in later litigation will look back upon when scrutinizing the legitimacy of the policies. In this way, the Supreme Court's artificial and restrictive form of rationality has colonized not just the courtroom discourse, but public discourse more broadly, which I submit is thereby harmed by the practiced insincerity, machinic logic, and moral shallowness that it engenders. But in the world as it actually is, it remains the case that the social distinctiveness of male and female has been firmly embedded in law and custom since time immemorial and across the world. Though admittedly, industrial society has collapsed a fair amount of it. But when a community appreciates and is in gratitude and cherishing the distinction and unique aspect of each sex, there really is no reason to diminish or to pretend away those distinct and unique features so as to make the sexes interchangeable equivalencies. Rather, as Margaret McCarthy has put it, the incentive should be to dig into the distinction and carry it up into the whole of life. That is, we should want society to promote the distinction and the difference, not cure it. Those comments offered, I now introduce you to our esteemed guest this evening. Scott Yenor is the director of the Kenneth B. Simons Center for American Studies at the Heritage Foundation, a Washington Fellow at the Claremont Institute Center for the American Way of Life, and a professor of political science at Boise State University. In addition to writing countless popular and academic articles on issues ranging from higher education reform to law to politics, Yenor has written 2 books on family policy. In 2010, the book Family Politics, The Idea of Marriage in Modern Political Thought, and in 2020, his book, The Recovery of Family Life, Exposing the Limits of Modern Ideologies. Professor Yenor again joins us to discuss the VMI case. It contains what the Supreme Court Historical Society has described as perhaps the most important majority opinion Justice Ginsburg penned in her 27 years on the Supreme Court. Please offer him your welcome.
Thank you very much. So let's start with today's headlines. In Virginia, there's this governor who's been elected. She wears white. And under her rule, it will always be winter and never be Christmas. And she has plans for VMI. Well, we'll get to that in a second. Jeff mentioned some of this stuff, but VMI was established in the late 1830s as a military school for boys. And it was really a prep for people to become members of the United States military. It has lots of famous instructors and students. Stonewall Jackson was an instructor at VMI. George Marshall was a graduate of VMI, I think 1901. George Shultz, Ronald Reagan's Secretary of State, was a VMI graduate during World War II. So it's a very small school, like 1,000, 1,200 students. The faculty were almost always graduates of the place, so they didn't have PhDs, fancy PhDs. They had like a tradition. The people who've been through it are the ones who taught there. And it had a manly code of conduct. The distinctives of the place were what they called the adversative method, which is a little bit like the Marines, or at least the Marines as they used to be. Whereas, like you'd have the leader of your group yell at you and tell you how lousy you are until you lost all confidence in yourself and clung to the group, and then all of a sudden, you were treated better. And that was called the adversative method. There's very rigorous physical training. You had to get up at 5 a.m. to go do it every day. If you didn't adhere to the rules, you had to stand outside in your bare feet all night, carrying your guns. And then they had this wonderful student-written code of the gentleman that governed the place. The last words of the Code of the Gentleman were something like, "We are in the tradition of the Crusader and the Knights, and we bring justice and protection to the weak." And it's kind of amazing. And that's how the school was governed until 1996, when the Supreme Court, as Jeff mentioned, in this VMI case, in a 7-1 decision, Justice Thomas's kid was attending VMI, so he sat it out. So I think it would have been 7-2, I'm just willing to say. When the Supreme Court said that state-funded male school, that this state-funded male school had to admit women in order to be consistent with the Equal Protection Clause of the Constitution. And then a year later, female students arrived. And then you kind of know what happened, don't you? The standards kind of changed. Code of the gentleman. What about the ladies? Now they have a code of a cadet. And it's not in the spirit of the Crusader and the Knight. It's in the spirit of human resource officers who embrace inclusion and welcoming everyone to VMI. After that, once again, you kind of know what happens, don't you? They were Me Too'd. They were DEI'd and George Floyd. They had a statue of Stonewall Jackson. That's going to have to go, don't you think? They had the first black commandant right after George Floyd. Established a DEI office, Title IX office. The Code of the Cadet was written by the HR office, not the students. It's enforced by the school's administration, not by the students. So there's been a decisive change in VMI since 1996. Now, Glenn Youngkin, when he took over as governor of Virginia, he made changes to the Board of Visitors. That's the Board of Trustees for the place. Put people who were unwilling to take Thomas Stonewall Jackson's statue off. People who were trying to maintain a few more of the traditions of it. The woke commandant, the black woke commandant, his contract was not renewed. But then, at the end of Governor Youngkin's term, he lost the control of the Senate, and they wouldn't approve any new Board of Visitors trustees. And that's how it was when our white witch took over. And she has proposed 3 bills in her first few weeks. One, new Board of Visitors. I guess that's not necessarily a bill. There's a bill to decline VMI's state funding, to withdraw it. And then there's a bill to take its governance model and fold it into the rest of the university system so that it would be governed by University of Virginia, instead of have its own independent thing. Because she looks at VMI and says, wow, this is a right-wing institution. And maybe it was, but really what she's doing is beating a dead horse. The decision to admit women into VMI was the big deal. And today, it might even be better to put the dead horse out of its misery. So we're going to try to tell the story of how this happened. It's going to be actually very much in line with Jeff's discussion, because so much of the legal controversy was fought in this shadowland of legal discourse, where the Virginia Military Institute couldn't ever really say what its school was about. Look at the evidence. What was the school about? The school was about cultivating manly honor, martial valor, and male leadership in society. That's what it was about. And in order to do that, you don't admit women. It's an all-male school because the goals of the school were thoroughly sexed. And let's be clear even more. That's discrimination. Like the school discriminated. Its goal was discriminatory, and the means that it used were discriminatory. Only men could be admitted, period. But they were never allowed to say any of that stuff. And that's where I want to draft a little bit behind what Jeff said, because the whole battle was fought in this legal world. We're abstracted from nature, abstracted from the goals of an institution. Instead, it was fought within the civil rights framework that anti-discrimination law takes place. Was VMI discriminating? Yes. Now the question is, was the discrimination legal? Was it constitutional under the Equal Protection Clause? Was it legal under the Civil Rights Act or the Title IX of the Education Amendments of 1973? That's the question, not whether the goals of the school are legitimate, but rather a narrower question: is it constitutional, is it legal? Now, the case began, interestingly, for those who are old enough, you can do the math here, in 1990. The plaintiff was found and brought the case to the H.W. Bush administration and said that VMI is discriminating on the basis of sex, illegally. And the Bush administration took up the case and spent 3 of its years prosecuting the case against VMI. So people think the uniparty just started. Now, initially, VMI had success in the lower courts. When you're facing accusations of sex discrimination, Jeff brought this up. I'm not going to mention that you brought these things up anymore, so I'll just go. But Jeff brought this up. You face what the court calls intermediate scrutiny. And what you have to do in this legal world is prove that the discrimination that you are engaging in is substantially related to an important government purpose or objective. And as VMI was making its way through the courts, especially at its first trial, it satisfied this requirement. I'm not going to read much, but I'm going to read just one line from the lower court decision here. VMI's single-sex status and its distinctive educational method represent legitimate contributions to diversity in the Virginia higher education system, and excluding women is substantially related to that mission. What was the important government objective that they found? VMI did not say, we have a unique mission to cultivate manly honor, manly leadership, and martial valor. No, they had to say that we are different. We contribute to the diversity in Virginia's system. This is what I mean by the case was fought in a shadowland, where Virginia could never really argue what their school was about, or why this unique form of education was valuable and should be preserved. As I say, the real argument that VMI wanted to make was that education institutions can shape the sexes to have different destinies in life. Men, VMI would want to argue, if it was going to defend its institution, should be raised to be leaders, sustained through manly honor, peer pressure of other men. And the ranking of male virtue, with this as a higher virtue, needs to be reinforced and shaped by society's institutions, including its schools. And excluding women from the school did a similar thing. It ranked the female virtues. It shaped and reinforced them with society, including government institutions. Women aren't to be warriors. A slew of women's colleges arose right when VMI was established in the 1830s, and those schools taught the softer professions, nursing, home economics, and such. They complemented the male institutions. But Virginia, as I say, could not argue that. The state had to argue that VMI contributed to educational diversity, or that it promoted excellence. So in fact, the way the courts worked out the question of VMI showed that the whole idea of pointing the sexes to different destinies, or somewhat different destinies, was itself unconstitutional. The lower courts then suggested that Virginia would have an even stronger case if there was a military institute for gals. So Virginia made one, though they were always on the horns of this dilemma. And the dilemma was this: not that many gals want to go to this. So if you build a self-standing institution, it will lose money and not be sustainable. And if you integrate it into an existing school, it will not look enough like VMI to say that it's similarly situated schools. But nevertheless, Virginia made one. The schools had to be, once again, here's the court's rules, substantially similar. So they created Virginia Women's Institute for Leadership. I just have to look down to remember how that goes. It was a leadership program with a ROTC element at a nearby school, Mary Baldwin College, I think it was. And the message was this, the court made this demand on them. If you're going to prepare boys to be X as a man, then you must also prepare girls to be X as women. In this case, it's warriors. And this was the ground that VMI had to defend itself on as it went to the Supreme Court. So there's these two shadow lands. On the one hand, it could never say what its school was about. On the other hand, it could never say that men and women could have legitimate different destinies cultivated by public institutions, which is, I think, both of them are like central to what VMI was. It could not argue that boys and girls should be raised differently. Can't do it. It could only argue that they could be separated for the same goals. And the separate institutions had to be substantially equal. You following me? So I can consider this to be a little bit like putting a gun to someone's head and then tying their hand behind their back and telling them to win the case. VMI could only argue that single-sex college education had value, but it could never say what its real value was. The formation of better men through institutions of manly honor. It could only say that adding women to the school would make the school less distinctive, but it could never defend its distinctives. I think I've got enough. You guys understand? Like, this is the problem. Still, as I say, VMI won in the lower courts, even on this hostile turf. There were apparently loads of scientific support for the idea that single-sex education produces higher graduation rates for men, or more educational excellence, better test scores for boys and for girls. So, gender-specific means could be used to promote gender-neutral goals. Higher graduation rates. So you can make the argument and you can provide scientific evidence to show that boys do 6% better on their SATs when they're in a single-sex environment. Girls do 8% better on their SATs when they're in a single-sex environment. Ergo, single-sex environments promote better test scores. And the Supreme Court has satisfied the glorious principles of equal protection. Once again, this is the hostile turf that they were arguing on. Now, the Supreme Court spilled lots of ink in this decision. Justice Ginsburg spends a lot of time showing that the Virginia Women's Institute for Leadership, or whatever it was, I'm sorry, I've already forgotten, is not the same as VMI. But as I say, that's a sideshow. She spends a lot of time showing that no important government objective is really served by these policies. Another sideshow. Most of the commentary on the opinion lives in that shadowland, like tries to prove that, oh, she should have looked at this study and she would have seen that better test scores were right around the corner. In fact, I would submit there is actually fundamental logic to her decision. If the goals of education for men and women are not different, then why should the means be different? If it is an unjust stereotype to say that men and women should be prepared for different destinies, then is it also not, possibly at least, an unjust stereotype to argue that the differences between men and women, when they're separated, will continue? The social science evidence to the contrary is just stereotypes too. If society now recognizes that having different social goals for boys and girls is wrong, maybe a gender-neutral reality should go all the way down. And this is the centerpiece of Justice Ginsburg's opinion. Once again, I said I wasn't going to read much. Here's like the key passage in my view of what she argues. The notion that admitting women would destroy the adversative system, and with it, even the school, is a judgment hardly proved. A prediction hardly different from other self-fulfilling prophecies once routinely used to deny rights or opportunities to women. Women's successful entry into the military academies, their participation in the nation's military forces, indicate that Virginia's fears for the future of VMI may not be solidly grounded. Of course, you can't prove a judgment until you've changed the institution. We'll get to that in a second. All the expert testimony in the world could not convince Justice Ginsburg that sex differences were natural or that men and women should have different destinies. So policies based on those claims are stereotypes. Surely the American women will soon adopt the fierce attitudes of the Viking shield maidens, or at least the ones on TV. I don't know that they were as badass as they appeared in Vikings. And they should become shield maidens, darn it. The idea that men and women should have different destinies is completely ruled out. So that's kind of her logic. And the wonderful thing about the case is that it was decided in 1996. It's now 2026. What have 30 years of coeducation at VMI revealed? Was she right that it was a judgment hardly proved? What can we learn about men, women, institutions, the court, after she, I'll say, destroyed the old VMI and created a new VMI? What happened? Well, what do you think happened? I kind of rehearsed some of this before. It took 2 years for the physical standards for men and women to be different. Why? Why did it only take 2 years? I mean, the guy who was Josiah Bunting III, who was the commandant then, he said it would be an insult to women to hold them to different standards than men physically. I'm not going to insult the ladies of VMI by holding them to lower standards. So what would happen? If you held them to the same standards, who would get kicked out? The ladies. And if the ladies get kicked out, what does that do to your equal protection situation? It's bad. So the logic of what you have to do in order to stay open is to start moving around the standards. The first to go was the 1.5 mile run, which I think they had to do in 12 minutes. And they changed it for the gals to 13.5 minutes. All numbers are approximate. I know it's a 1.5 minute, they gave them 1.5 more minutes. And then they went to strength training and stuff like that. Bunting insisted that the ladies get crew cuts. You want equality? crew cuts. It's very demeaning. So it got like 4 years till the bob was legit. And now, as I understand it, you can have your hair down to below the shoulder blades. So things have changed in that way. Physical fitness, grooming standards. The place had no privacy. Like literally, the showers were like the showers used to be when I was in high school. That there's showers, there's no stalls. Everyone, that's the only place you could go. That doesn't work as well. Privacy was abolished for the men, but reinstated, obviously, when the women come there. Of course, there's never enough women because if only 20% of the class is women, or let's start more realistically, 8% of the class is women, doesn't that kind of create an environment where they don't feel welcomed? That number needs to go higher in order to bring more people. So different admission standards come in. But the real flip happened about 12 years ago when they changed the code of the gentleman, which had governed the place since 1839. It used to be that, as I say, the administration of the school had nothing to do with this code. And any upperclassman could come up to a lowerclassman and say, recite it. And if they didn't do it, punishment. In front of student-led honor tribunal. It wasn't an honor. I can't remember the name of it. And there's the administration had nothing to do with it. Now, the administration writes it. It's the teachers that require the statement. And then if you don't state it properly, you go to the dean's office. So the idea of student government or Republican government or self-government has been completely erased from the place, replaced with managerial elitism, no doubt. Maybe it's better for that. And once you have that, the DEI office and the Title IX office are right around the corner, and they were established shortly after that to oversee, to make sure that no one was requiring undergraduates to say something that they shouldn't want to say. And generally the place is, as I mentioned, pretty woke. So we've tested, we have a wonderful situation. We've tested Justice Ginsburg's reasoning. It is hardly proved, she said, that VMI would be changed by admitting women. But every aspect of the school has been revolutionized and changed. So what I tried to do in the Provocation, it's a little book that I wrote for Claremont in September, was provide a blueprint for overturning United States versus Virginia, first of all, on its own terms, which is to say, you made a prediction about the future, and it has been invalidated by subsequent evidence. The factual basis of your decision has now been proved, actually disproved, so that there's a record that you can use to overturn the case. But then to point out that it's a shadowland that the case was taking place in anyways, that is, Virginia couldn't actually argue for what it was for. It had to argue about excellence and test scores and graduation rates. And to point toward a anti-discrimination framework for understanding these cases. And I think it's important to do this for a couple reasons. First of all, even the lame VMI of today is too much for the Democrats. Thus the proposals that the White Witch has made in Virginia. And my approach to that is, if it does, it's the Drago line, right? If it does, it does. It's not what it was, and it's not necessarily the hill to die on anymore. But the reason still to fight for it is because other states are actually establishing single-sex military schools that are, almost part of some sort of grand design from someone's mind, where the states are establishing, they have boards, they'll be opening next year, and in the tatters of VMI and Blue America and its institutions, red American states can act but they are restrained by decisions like this. So the decision has to be challenged. There needs to be an all-male school in order to challenge the school or the decision. And I think that's green shoot is in the offing this year in West Virginia. So with that, I close my remarks and look forward to your questions. 28 minutes.
Anybody? Yes, sir.
So I was just curious, if the state decides to start a military college, are there certain qualifications that college needs to meet on a federal basis, or is it just they can just do it and have their own guidelines and their own curriculum?
Well, they can try. They can try, and yeah. So actually, I should take a step back for a second there, because VMI after the decision, like it faced a choice, and Jeff didn't mention this, but it faced a choice. It could either go private, or it could integrate, and the Board of Visitors of the university at that time debated for, I think, 3 meetings, and by a 9-8 decision decided to integrate. And reading the minority report of the Board of Visitors, it was written by 5 of the 8 who voted against it, or at least they're the only ones who put their names on it. It's like, well, we know what you voted for, you might as well sign it, darn it, don't be a loser. Is like the outline for what happened. Like, it's the outline for what happened. Like, and so it's haunting, but it's also just like common sense. Exactly what you'd expect would happen, happened. So I left that out of the story. I just wanted to add that. So now to your question. So what would have to be done to establish this? Well, a state would have to establish it. And any state can do it. And then what will immediately happen is litigation. And the litigation will be based on the precedent of US versus Virginia. And with the evidence we have, like, look, I don't think the evidence really matters to these people. But with the evidence we have, you can enter courts and you might be able to win. The court is completely different now than it was in 1996. And the strong record of showing what has happened to this school might actually afford like a return to Justice Scalia's dissent in that case, which is, you know, I think like a B+ for sure, but also kind of A aspects to it. But so like that's all it takes, and it should be done strategically in a circuit that has friendly people, so that you can actually get a trial record to enter all of the stuff that has happened at VMI since the decision. I think West Virginia is a good place for that. Yes, go ahead.
Do you have any other similar case studies that come to mind? I'm sure we can, look out on the country and see a lot of institutions that have declined as a result of these sort of rulings. But are there any that were similarly kind of embroiled in a legal battle or became precedent that you would recommend for us to review?
I mean, the Citadel case happened at almost the exact same time. And then the record is just as obvious in the case of the Citadel. I think Nancy Mace was the person who integrated it, and her dad was the commandant then, or something like that. So it's a little weird. But the other thing is that that people have been trying to establish single-sex public schools, since this case. And it usually takes litigation that lasts about 6 to 10 years to establish a single-sex classroom anywhere. But once they're actually very well studied once they are established. And, but the record isn't this kind of lead pipe cinch argument. It's not like the guys who are in all-male schools glow and the guys who aren't in all-male schools don't glow. I mean, it's like, making the argument strictly speaking on the terms of social science and the outcomes, on gender neutral outcomes, is like, that's the shadowland that's the area within which we are like not making the argument for what we really believe. Now, Jeff mentioned why that's the case. Like, in order to win, you have to win, and you have to fight on the terms that are there. But like, I'm much more in favor of having losses worth having than wins that aren't worth having. And that the real place to plant the flag is that schools, institutions dedicated to manly honor and feminine virtue are themselves good. They're part of an entire societal formation project where men and women are pointed towards somewhat different destinies. Now, like, I don't know where I draw the line as far as where you've gone too far. Like, I feel bad about some of the laws that existed in the past. Like, there was laws that prevented women from being lawyers in Illinois. And the Supreme Court said that was all right. I don't know if I want to say that, and I don't know if I believe that. Those are two different things. So there may be instances where it's possible that you have problems in the other direction, but as far as finding other examples, the Citadel, and then you can also look at private schools that have integrated. You guys seen the movie The Emperor's Club? It's a classical education school or movie. No one has seen this movie? It's got Kevin Kline plays this old-time teacher, and it's an all-boys school. And he goes and he does a great job. He's the Roman history teacher. And then he leaves for a while because there's been a scandal where a donor had bought his kid some award, and the school looked the other way. And then they come back, he takes 10 years off and he comes back, and it's like the United Nations in that classroom. It was all like old Southerners at the beginning, and he comes back and it's half women, and it's the United Nations, it's racially and sexually integrated. And it ends, it just shows you a little snippet of this world. And it's designed to show you that nothing would ever change about this tried and true place when it's integrated like that. And I love the movie right up to the end, when I'm like, oh, now I have to live the lie. And so I'm not going to recommend that movie, but that would be another thing you could look at and see the what you have to believe in order to believe what the Supreme Court said here.
Jeff pointed to equal protection, novel understanding of equal protections afforded by the 14th Amendment. In your opinion, is this case, the VMI case, the origin of that, or is it simply an application of a reading that the court had established?
Yeah, it pre-existed because the categories were already there, and they created that shadowland within which the legal battle was waged. Jeff would know more about the precise origins of when the intermediate scrutiny for sex discrimination came up. It was probably in the mid-70s, or in cases like Idaho had a law. There was a big dispute in Idaho. I can't remember the name of the case, but it was the same name against same name. Doesn't matter. And but the case was Idaho had a law that said if the son died, the father is automatically the Reed versus Reed. Automatically figured out what to do with the will if there wasn't a will made. And the Supreme Court threw that out, and it said, women can do what the will stuff too. And that, I think that might be the origin of it for this case, but Brown versus Board had suspect categories and stuff like that. So I think the equal protection analysis precedes the sex discrimination stuff. And the crucial thing is justice requires that you articulate why a bill is passed, but the anti-discrimination law requires that you hide why the bill is passed in order to argue for its validity. And so it ultimately, and I love the way you put this, it corrupts the legislative process and public discourse around the topic, so that you actually lose the ability to have contact with nature and the fundamental categories of human life, because you're living in this legal world.
that she more or less just wrote off the entire goal of VMI by mentioning, that there are no God-given roles for men and women. That's kind of baked into the Equal Protection Clause. How do we go about overturning that Equal Protection Clause as kind of assumed in Justice Ginsburg's decision?
Yeah, I mean, it's a big project. That's a great question. So I think Jeff would be a better answer, give better answers to this. I'm a political philosophy guy. I'm just a simple country boy, really, and don't understand all the fancy legal terms. But my understanding of the Equal Protection Clause is that laws offer protection, and it needs to be offered equally. So, for instance, if someone gets murdered in your district, and you investigate the white guys who get murdered, but not the black guys who get murdered, you have an equal protection problem. And what the civil rights laws do is say, now the U.S. District Attorney will come in and oversee the investigation and prosecutions in your area because you're not providing equal protection of the laws. If there was no law against murder, which I think there probably almost always would be, but if there was no law and everyone was just allowed to kill everyone else, they wouldn't have an equal protection violation. But the goal was to make sure that everyone got equal protection of the law. Does that make sense? So, everyone who gets pulled over for speeding thinks that equal protection has not been adequately applied to their case. You following me? And that's definitely happened to me. I once switched a lane without putting on my signal and got a ticket. And like I said, this seems to be an equal protection problem. I've seen many people. Anyway, so and that's basically where it stood until I would say the revolution of the judiciary in 1938. In a Caroline Products case, there's a footnote, famous footnote 4 of this case, where the Supreme Court says, yeah, we're going to stop worrying about federalism and we're going to start protecting discrete and insular minorities because they don't have, among other things, fundamental rights, but the thing that matters for equal protection is discrete and insular minorities. So this is where the idea of discrimination being a violation of the Equal Protection Clause, I think, if it has an origin, it has its origin at that moment in footnote 4 of the Caroline Products case, which was about affirming something that the national government did. But instead they're like, yeah, we're done looking at Commerce Clause stuff. Instead, we're going to focus on discrete and insular minorities and other things. So I think that's the origin of it. And in order to get at a revolution in Equal Protection Clause, you have to kind of get rid of what I would call multicultural citizenship, which is the idea that discrete and insular minorities, as discrete and insular minorities, deserve protection and not forcing them to integrate into the rest of the community. And that's my quick way I would think through the issue. Is that in order to get at the Equal Protection Clause or the approach that is taken now, you have to have a more robust understanding of forming citizens in a common country as opposed to maintaining isolated communities within a country. Good luck with that. But I think actually there's almost been no better time because the crisis of the multicultural citizenship is our crisis. Letting in people who are tribal as opposed to believe in the equal protection of the laws is now becoming a huge problem for the country. And it's difficult to imagine how it can work out unless there's some way of integrating us into a different way. So I think the crisis of the discrete and insular minority is kind of our crisis. Joe?
You mentioned you rather have noble losses as opposed to bad wins, something like that. Tie that into the attempt to get to, say, sex standards, but within the current civil rights, equal rights regime. So thinking of the Secretary of War establishing, I'm going to raise the bar for everyone again. So yes, men and kind of male-female differentiation, but by simply making it about the standard, you're still operating within that framework. So do you view something like that as, that's a good move, it's moving the ball down the field, or do you view that as reinforcing that kind of regime?
Yeah, I do view it as reinforcing that kind of regime. And the only way in which it can move the ball down the field is if it is coupled with an argument outside of the civil rights logic. So that if Secretary of War Hegseth said something like, we're going to have one high uniform standard for men and women, which he did say in that Patton-like speech, and if women can't pass it, it is what it is, I think were his exact words. And so I like that. But that's still within the civil rights framework. So that needs to be complemented with, and an all-male military will be good for men and good for the country, too. It's not like a concession to the civil rights thing. It's actually something to celebrate, because men need to recognize their role in society as protectors and providers and pillars of the community. And the military is a way in which that happens. So it's not something that we should apologize for, but it's actually something that we should feel all right about celebrating. And then it could move the football down the field. And I think it's much easier to do it on the sex issue than it would be on any of the other things. Yeah, right.
Similarly, would it not be a problem if you had the reversal of this process with respect to men and women? So VMI comes back as an all-male institution, but there's no restoration or attention to the question of the virtues that they were trying to instill, which would likely entangle you with First Amendment questions then of what values, what virtues, says who. And without that, you could have a perfectly wonderful, manly school for warfare training a bunch of barbarians.
Yeah, no, I appreciate that. Justice Scalia's dissent in the VMI case, I mean, it's really good. And the line that Jeff quoted before is a great line about there's a lot of condemnation of the founders and the majority's opinion, but let me say something on their behalf. They left us free to change. And then and then he goes after how the court imposed its fads onto the Constitution itself. But it ends with the code of the gentleman, like he puts the whole code of the gentleman in the decision. And then, I'm going to start bawling because I love this kind of stuff, but he says, in living memory, I'm shocked that there's still a school that says this is what it's about. And that we're intentionally destroying it is just unbelievable to me. And that's the end of it. And I mean, he says it much better than that. And the way I put it is within living memory. I mean, I was 25 years old when this case was decided. Within living memory, a school dedicated to the code of the gentleman, with the crusader and the knight as its, the trailblazers that it was following in. It existed in my lifetime, in my living memory. I remember when this case was decided, and I didn't really realize what a big deal it was then. I mean, I knew it was I was opposed to it. As I like to say, I've never been a feminist. So many people kind of get over it, but I just never have been tempted by it. I've watched too much girls' basketball to be a feminist. And so yeah, I mean, I completely agree, because it wasn't simply about training the barbarians. It was about the importance of public service, but it was, Republican government Like these guys all learned how to govern themselves by the way the school governed itself. And the people were really taught leadership in a very practical way, not by reading 7 steps for leadership, but actually having to have cadets under your control. So totally embrace what you said. I think that that's right.
Scott, what are you working on in that department? You alluded to your political philosophy background. You surely have some ideas on policy issues and other things we ought to be working and thinking through.
Yeah, I mean, there's all right, I'm going to put this like this. I think there are other principles that matter in addition to the anti-discrimination principles. And those principles should be placed in law. So for instance, the ability of business owners to support the traditional family with their hiring practices, the way they allocate hours and payment, might be something that could be acknowledged in law. And that might have implications later on, like it might run up against the anti-discrimination laws. But for instance, like I'm really in favor of female opportunity. And what I mean by that is, in one case at least, that I can imagine there could be employers that would say, I want to hire lots of part-time moms to do some side hustles for me. But I'm not going to offer the same opportunities to men. And I think that'd be great. I think it already happens. It happens to be illegal under the '64 Civil Rights Act and the Equal Pay Act and all the other things. I think it should be legal. And for employers to treat like side hustle moms different from breadwinners. And I think that principle could be expanded in other ways. So I think, and then that would just kind of carve out certain exceptions to the anti-discrimination principle that could be in favor of the family. I think there are other ways of doing that. Once again, I'm not a legal theorist, and I hope that at some point there are people who like do this for a living, who think about how to do this functionally. Like I just work at Boise State, you know. But I think that would be a really fruitful way to go about it. I think any kind of frontal assault on what Americans consider to be like one of our sacred laws is not bound to have success in the short term or medium term. So other principles should be introduced into law, like freedom of association, or the ability of business owners to support the family and follow their conscience in supporting the family as they see fit. That might have really untold implications. Well, I'm giving you good stuff here. I mean, that was like, that could get me fired right there. Don't you realize that?
Any additional questions? Do you want to chat for a bit, or?
What do you mean?
I mean, I could throw some things at you.
Do you guys want to see us perform for a minute? All right, we're going to perform.
I'm interested in a number of things that came up during the course of
Can you speak up, Jeff?
your interactions. Yes. Joe asked a question about noble losses versus less than admirable victories. I wonder if we might elaborate on that a little bit more, and don't downplay your status as non-lawyer, because I think there's a kind of prejudice that folks like me carry, because we really feel the pressure of needing the win, and that sometimes can overcome our sensibilities with respect to, is this appropriate to approach things in that way? Is the short-term gain always the right thing to do, as opposed to trying to attain to some more pure presentation in the law? That's a toughie. Particularly because of our ethical responsibility to zealously represent our clients and their interests. And going into the court intending to, or expecting to lose, but vindicating some proper principle isn't necessarily a good way to keep making a living. So you see the kind of pressure within the profession that we face that keeps us conservative, not in the sense of politically, but conserving the system as its rules operate. So I'm interested in your proposal, which I'm very sympathetic to, that we might be too many more wins like this and we're done for.
Yeah, you guys pay attention to the Idaho oral argument at the Supreme Court?
The Hecox case.
Yeah, the women in sports case. This just was argued maybe 10 days ago, or I can't remember exactly how many days, but and I'm sure I'll be talking about this with a friend tonight who was there. And I listened to the oral argument for that, and look, like here's the issue, like in that case, it's just another illustration of the problem. Like, are you discriminating against transgendered people? Like, if you say no boys and girls sports, are you discriminating? Yes. You're not allowed to call it that. Or if you do, you've given away the store. So the Supreme Court, and that was the dance that the Idaho Solicitor General had to perform in front of the Supreme Court. And I don't know that he performed that dance well. But it's an unenviable, it's not a position I'd want to be in, because it's obvious that it's discrimination. And are trannies discrete and insular minorities? Oh no, but it's certainly discrimination. But in an anti-discrimination regime, you're not allowed to say it. So do you keep, how do you try to win that case? Do you say, this is a really important discrimination, it's grounded in nature, and without it, you can't have civilization or human life, something like that. It would be a good idea, if you can't open up that argument, then you're in the Shadowlands, where you're zealously representing your client. But I just think the reality has to, it has to shine through on these kind of things. Just like the same-sex marriage. The same-sex marriage debate is another example of it. And is it discrimination to say gays can't marry? Yes. But if you say that, you're done. Or you have to so that there's a compelling, and that particularly can't remember what the interest had to be. So so maybe discrimination itself needs to be defended as important element of human life, without which, at least in many areas, really impossible. Can we distinguish between a citizen and a non-citizen? I really like to be able to discriminate against non-citizens. But you can't vote in our elections if you're a non-citizen. Is that discrimination? Yes. Can you have a nation without it? No. So the concept has to be revived. And I just don't see any way around it, because otherwise you're living in a shadow world. I don't know what it looks like in front of the Supreme Court to do that, by the way. Except you write it, and then you say, all of the stuff you guys are doing is fake. And maybe some of them will blush. Wouldn't that be something?
Well, it suggests that there's a role to be played by persons who are not practitioners in front of the court. Because if you were ever to do that once, that's the last time you'll ever appear in front of them. So it would have to be the right people making those arguments, and it would not be in the courtroom itself. It would be kind of ginning up that kind of discussion outside of it, which is, I think, very important to do. Lawyers that practice before the court can't be the ones who do it. They have to be much more subtle in their presentation, although I think they haven't been doing enough subtlety to be introducing that. So, but in all of that. The work of Justice Ginsburg is fascinating, I think. She argued in front of the Supreme Court 6 times in private practice, winning 5 of those cases in various and sundry equality cases. So this was her cup of tea. And so I think she really felt like this was her opportunity to go all the way, smack to homer in this case. But her feminism, it's interesting. because I often say this to my students, it involves her elevating women by saying their fullness of life can only be attained insofar as they can become men. So the standard of goodness, of liberty, of a life worth living is a manly one. So everything that is associated with femininity must be suppressed. This is why it's absolutely vital for her to have an abortion right, because men do not have to deal with the inconveniences of pregnancy. And if women are to become men, they must also be able to rid themselves of the inconveniences of pregnancy. There is something of it strikes me as extraordinary that the feminine-hating nature of feminism doesn't get more attention, that we celebrate the work of the likes of Justice Ginsburg, who is a genius, by the way, in my estimation. I don't know how you look at her life without being impressed with her aptitude and verve and accomplishments and so forth. But what she was up to was, I think, utterly dreadful and inconsistent with civilization for the reasons that you have mentioned. It seems to me that there's a great rethinking that needs to be going on with respect to whether women themselves are being served in the ways that she was putting forth, and that the Supreme Court has been.
Yeah, I'll just say two things about that. First of all, I consider her more of a hard worker than brilliant. But that's maybe that's not one of my two things. I don't want to necessarily waste a bullet on that, but definitely a hard worker. Of all the workers, she was one of the hardest workers. And as I understand, the issue of femininity, I think, is actually a very key one. And I just kind of wrote about that this week. I have a friend who just finished writing a book called Something Wicked. Carrie Grass is her name. Something Wicked is the name of the book. Why feminism can't meld with Christianity, or Christianity can't meld with feminism. I can't remember if it's peanut butter and chocolate or chocolate and peanut butter. And you know, and she's written kind of similar books in the past, we need to learn how to talk about virtue. And I think there's a tendency, I've done it myself once or twice, to say that virtue is kind of sexed. That is, there's male virtues and there's female virtues. And I think we shouldn't say that. I think we should say there's virtue, and we rank them differently in men and women. So a man, and here I'll just tell a story that when I was dating my now wife, then girlfriend, she called me up. I lived across town, and we have a bat in the basement, and we need you to come and kill the bat. And I don't really like that kind of stuff. I don't like mice or bats. But I said okay. And I went over there, and there was these they were all on the girls' basketball team, and they were cowering in the corner, just get the bat, don't do. And they were just like that. And I went down there, and I got a tennis racket, and I found the bat, and I whacked it and killed it, and I brought it up dinner. And so, I mean, I'm not trying to say I was Hannibal here, but I showed courage. I overcame my fears, and I'm sure that I haven't ever asked her, but I'm sure she was impressed, my now wife, then girlfriend, that I would kill the bat, even though it was kind of against my inclinations. And whereas, did I look at her and say, "What kind of a woman are you to cower in the corner at a bat? It's just a rodent." I didn't say that. It's charming that you called me up to have me kill the bat. And that, what is that? There's a little indication there. It's kind of cowardice on her part. Let's call it that. It's a standard of virtue. But in her, it's not a big deal. I'm not going to judge you badly as a result of that. There's one standard of virtue. You failed. No one cares. There's one standard of virtue. I passed. Look at me. I'm a catch. And so we should just recognize that they rank differently in men and women. And to me, are you in favor of a strong woman? It's a matter of taste. There could be plenty of great women who are strong, I guess. There's plenty of great women who aren't strong. It's not like the defining attribute. Just like you're being known for your mind. It's not the defining attribute of a man or a woman. Like, it's just like garnish. And so it's a question of where the virtues rank in the sexes. There's one single standard, but they register differently in the sexes. And something is more important. And so in this way, you're allowed to say things like this about Justice Ginsburg, that sure, she thought female strength was good, and I guess that's fine. But to think that that's the whole of virtue, or that's what constitutes feminine virtue, is an obvious error. And it's the typical error that people make in moral reasoning, which is mistaking the part for the whole. And so, good job, you got something kind of right, but just didn't quite know how to rank them. And so I think we could talk, like conservatives, Christians could talk better about virtues by recognizing that there's not a double standard. I'm opposed to the double standard. It ends up just being worse. Like, is it a vice if a man is an adulterer? Yes. Bad. Like, I think we can all sign up for that. It might be higher, it might rank higher though, or lower, depending how you look at it, for a woman. Does that mean there's a double standard? No, they're both bad, but they rank and register differently in the sexes. Like, who's worse, the adulterer guy or the coward guy? I think it's actually a debate, but I don't think it's a debate for the females. And so, I look at Justice Ginsburg and I see her putting forward or elevating one understanding of womanhood that elevates one aspect of character that might be good and missing the whole of the social fabric that is necessary to actually cultivate properly ranked virtues in men and women. And I think that's the problem with our liberalism. We're not really allowed to think about how the virtues should rank in men or women, or really even to talk about it. And we tend to overreact by saying that virtue is sexed, whereas I think our position is more nuanced than that.
Well, we'll call it quits at that. Thank you all again for coming.
Thank you.